is case number 23-1050, SFR Services LLC versus the Florida Department of Financial Services on behalf of Avatar Property and Casualty Insurance Company. Counsel for the appellant, how much time would you like for rebuttal? Whenever you're ready, ma'am. Yes.
Medication that gives me dry mouth. Is that okay?
Yes.
This is a pretty straightforward legal issue that I think has been well settled, particularly with the recent proposed amendments to 1.442 and the committee comments to those. And
Counsel, I did have a question to you related to those committee comments. I noticed that those committee comments were, according to your appendix, submitted around the 2021 timeframe. They appear to line up directly with the arguments that you make in your initial brief. By putting them in your reply brief, you didn't give your opponent an opportunity to respond to those arguments. So how are those arguments not something that should have been put in your initial brief rather than attached to a reply brief? It struck me that this is not some new case that just came out recently. These committee notes have been around for a little while. Is there a reason why you didn't put those in your initial brief?
There's not a specific reason. In another case before the court, I had to do some detailed briefing after the fact on whether or not the proposed amendments to 627-428. So it was something that I discovered during the course of briefing that and working with several, organizations that submitted amicus briefs. So it just simply wasn't on my radar. It was not intentional.
Okay.
By any
It
stretch.
came to your attention after you had submitted your
Absolutely,
brief?
yes.
Okay.
I did not
Thank you,
have it
counsel,
on my
for that
radar.
clarification.
So I have I litigated a case in a similar procedural posture in front of the third, the Safe Point versus Jeannie Williams case. So a lot of what I was drawing on were the arguments advanced in the initial brief were the arguments advanced there. And obviously the third district agreed and they reversed.
Can I ask you about your second issue on appeal relative to your motion for fees?
Sure.
The insurance carrier is insolvent now, correct?
Sure.
Right. Is your ability to recover fees a moot point in light of the fact that if it goes back, I assume you would have to substitute FIGA, and FIGA is going to say, hey, we can't be responsible for fees. So
My friend Figa is here.
but that's what. Is there anything that the trial court can do if you're correct on your second point?
I'm not sure it's possible. Obviously, FIGA has made the decision to come in and continue to contest.
Well, I understood that it's the department that's here seeking
Correct,
to,
you're right. I'm sorry.
seeking to
The
recover the
receiver,
judgment as opposed to, because there was no substitution of FIGA below, correct?
Not until the appeal had already been. Well, so the procedural posture was the final judgment was entered after the stay imposed by the filing of the insolvency proceedings. So the final judgment was entered in the name of Avatar. We moved to vacate it. I think there was not relinquished, released, but ultimately the FIGA was allowed to substitute into the case. And then, so.
Was your motion ever ruled on, your motion for fees? You have the December 2021 order that followed the November 2021 hearing on the competing fee motions.
Okay.
And then you have the final judgment itself, but I didn't see anywhere in the record where there was a disposition of your fee motion.
I mean, I think it's implicit in where the trial court landed, which was she disagreed with our interpretation of
We usually
768.
review implicit rulings like that.
Well, I guess my point is,
I mean, I appreciate that there's an implied denial. You weren't going to be granted fees. But I suppose, is there anything inconsistent with the conclusion that, for example, you could have recovered a judgment for your pre-offer fees and costs, which then would have offset the insurance companies.
Say that again?
Couldn't you have recovered a judgment for your fees pre-offer under 627 from the insurance company? I appreciate we're talking about pre-insolvency, and none of this may matter at this point, but
At the time of trial or at the time the offer was served?
from the time until the offer was made under 627, couldn't you have said, I'm the prevailing party, which is what you did, and I want a judgment for my fees and costs incurred to the date of the. It's what you're essentially asking us to remand to do now, but I don't know why the entry of a judgment for the insurance company on their fees would render that separate judgment impossible on your motion for fees below.
So I'm not, you don't understand how the judgment in favor of the receiver for Avatar would render, I'm not following the question.
Well, you have a judgment that was entered that's on review. And that judgment, as I understand it, awarded fees for the insurance company. And also, as I understand it, and I could be wrong, disposed of the main claim, because up until that point, there had not been a judgment of the, as it relates to the homeowner's insurance claim.
That's correct. It took yes, after the trial, the jury verdict did not result, the jury verdict in favor of my client did not result in the judgment in their favor.
Right. And because the amount of the fees was in excess of the $9,000 damages amount, judgment was entered for the defendant, which is totally what 76879 calls for.
Right. But you're missing the step where the verdict is not the judgment obtained.
Well, no, I understand that. And I'm not talking about your first issue. I understand your first
Okay.
issue. I'm just trying to figure out what's going on with your motion for fees and whether or not it's ever been ruled on.
Well, I would suggest that they did rule on it because, we advanced the proposition that, we should have fees. But, if this were to be reversed and the correct law, with instructions to apply the correct law as to the judgment obtained, then there would be a judgment entered in favor of the insured, and then, then another motion for entitlement could be filed. I mean, that happens routinely when there's something, reversed. And
I think you gave this answer to Judge Netcher, but I just want to make sure that I understand it correctly. This is because of the insolvency as it relates to your ability to fee collect an academic exercise.
no, it's that my client is out of pocket $110,000.
Well, how is, in terms of attorney's fees, your client going to be able to recover that against FIGA?
I am not necessarily sure that they can. I'm not going,
But I mean, you're involved in a lot of these particular issues with insolvent insurers. So I can't imagine that this line of questioning is foreign. Are you mindful of any way under any existing law where you could recover your fees in this particular case against FIGA? I'll say that I'm not.
well,
But I'm willing to be disabused of that notion.
Well, so I understand that under the petty case, that even an order of entitlement prior to a judgment being entered, done, no fees, FIGA comes in. To whether or not this particular proceeding constitutes a continued attempt to deny coverage or avoid coverage on FIGA's part, I think could possibly be an argument advanced to the trial court, because that's essentially when.
How are they trying to do that when it's your appeal, though?
Well, but they're defending against it, and they're taking the position that the jury verdict came back in favor of my client, and they advanced the position to.
Let's say we agree
To
with
avoid a
you.
covered claim.
Let's say we agree with you on the first issue,
Mhm.
and basically reverse for the entry of a new judgment that's consistent with the jury's original verdict.
Right.
How are you going to expand on that judgment with it being FIGA on the other side now as opposed to Avatar?
So I don't know that that's necessarily something that could happen, but what could happen is the judge could apply the correct rule as of the time the proposal for settlement was served, look at whether the judgment obtained exceeded the proposal for settlement,
Right.
and not apply the procedure in 768.79 and offset the verdict. with-
Yeah, my questions all presuppose that that happens.
Okay. I don't know that, I mean, I don't know that there will be a judgment of fees. I simply want,
Let me ask it this way. You had answered in response to an earlier question that theoretically your client could, once there's a new judgment put into place, say
Right.
we remand and we agree with you on that first issue
Right.
in terms of the white formula, and there's a new judgment put into place. Could you in good faith file a motion for attorney's fees at that point?
the only way I could file a motion for attorney's fees in good faith is if there was, this proceeding could be seen as an attempt to deny a covered claim. Otherwise, I could not.
Do we have to, if we agree with you on the first issue, do we have to, because we can't direct the trial court to enter judgment against Avatar, and FIGA hasn't been substituted in, how is that going to work just from a procedural standpoint? We have to send it back and direct that FIGA be substituted, or just leave it to your good graces to get that done at the trial level?
It's my understanding that FIGA was substituted.
Okay. Well, then-
I could be wrong about that, but they are in the case, in the lower case. So, and I think the judgment might have been vacated and re-entered, and yeah. So I think that they are, but I think I think the judgment needs to be reversed for the trial court to correctly apply, the white formula that as recently as 2021 in the CCM case was reiterated, and what happens from there, I don't know. I just know that the fee judgment that resulted in my client from the erroneous application of this law was almost $110,000. So for that point alone, this is not an exercise in an attempt to recover attorney's fees. I was not trial counsel. I have not filed a motion for attorney's fees in front of this court for that reason, because I think that there are factual issues that would need to be fleshed out as to whether that's appropriate. And obviously this court doesn't sit, as a fact-finding tribunal. So I hope that answers the question sufficiently.
Counsel, I had a question taking you. I know you weren't trial counsel, as you just said, but let's say you were trial counsel and you had been served with this proposal for settlement from the defendant for $15,000 with the express language in the proposal, exclusive of all taxable costs and attorney's fees. And you just mentioned your client is out a significant amount of attorney's fees.
Mm-hmm.
Let's say you accept this $15,000 proposal for settlement. Would you then go to the trial court and ask for your attorney's fees and costs in addition to the $15,000?
Yes, I think that under the confession of judgment doctrine, just depending on, once the money was paid, that's how typically.
And
it
this
would
was
work.
exclusive, and the proposal itself was exclusive of fees and costs. So I suspect that the insurance company would have expected that.
They would have. There's some war stories outside the record that, these exclusive proposals for settlement are not always not contested. So
You have said the 100 and so. I'm sorry.
Yeah,
Sorry, go ahead.
would you mind if I followed up on that? So if you were seeing this proposal for settlement that they made to you, exclusive of all taxable costs and attorney's fees, is giving them the ability to later ask you, or for you to step in and ask for taxable costs and attorney's fees, how can you take a position here today to say they can't do the same thing? That the trial court couldn't have said that this proposal, based on what it says, 15,000 means 15,000 exclusive of fees and costs. Kind of what's good for the goose, what's good for the gander. If you're going to go in and you're going to say, I can accept this, and it's $15,000, and I get my taxable fees and costs. But if it's rejected, the taxable fees and costs are tacked onto this, and we get this amorphous final judgment that can never effectively be beat. How do you respond to that?
So just to make sure I understand the question, you're saying that because of the insolvency?
Well, your position is, no, forget the insolvency.
Okay.
That was their question. That
Okay.
was my question. My question is focusing on the language of your proposal for settlement and your request for this court to look at the White case, apply the White formula in your circumstance,
Mhm.
even though we all would concede that White did not have your facts. White did not have these specific facts where we have a proposal for settlement that says exclusive of taxable costs and fees. That wasn't White. That wasn't any of the cases that you've put before us, save one federal case of a senior judge, which is absolutely not binding. But as for the binding authority that you've put, or even persuasive sister DCA courts that you've put before us,
Oh, that's right.
this isn't here. So it would seem to me work a fundamental unfairness if you're allowed to interpret this to mean that it's $15,000 plus I can then later go to the court and ask for my taxable fees and costs. However, Judge, how I want you to look at it is I don't want you to include, excuse me, I do want you to include that $15,000 to include taxable fees and costs. That's what you're asking us to say. 15,000 includes everything. It includes the judgment obtained equals taxable fees and costs, correct?
No, what I'm saying, and I understand, just to make sure I have presented the court with several cases, the Safe Point versus Williams, on where there was an exclusive proposal for settlement. There's several cases cited in here that have those facts. But I understand that, this court's taken a position that, we're not necessarily bound by the other opinions that are out there. So, but, I'm the correct way for this to be handled is for the day, for the fees and costs and prejudgment interest as of the date of the proposal for settlement, to be calculated, an evidentiary hearing to be held. That's exactly what the third reversed for in the Williams case. And that's the judgment.
My point is, counsel, that 15,000 that you're looking at here today, and you're telling us that should be under the White formula inclusive of attorney's fees and costs.
No, I'm not.
Then don't you lose? I mean, isn't that your whole argument, that the 15,000 should include the net
Okay,
judgment?
I misunderstood. Inclusive in the term
Yes.
used in the procedural rule.
Yes.
So, the procedural rule just the procedural rule has the inclusive and exclusive language, but that's
No, I'm talking about
Okay.
procedural statute. Let's focus on the statute. Judgment obtained.
Okay.
Judgment obtained does or does not include fees and costs.
So I accepted the 15,000 exclusive.
No, at this point, I'm asking you in your position in this appeal. I guess I've moved on from my hypothetical because I don't feel like it's really connecting. So
Okay.
I'm just going to shift, and I'm going to say your position before this court is judgment obtained equals fees and costs, correct?
Judgment obtained is the judgment obtained is the verdict plus any attorney's fees and costs and prejudgment interest.
Correct.
And for purposes of comparing a proposal for settlement to determine whether it triggers fees is to compare what the judgment obtained would have been on the date.
And I guess that's my point, counsel. And I appreciate, I feel like we've connected now.
Okay.
So that's your position.
Yes.
That's what judgment obtained means,
Correct.
regardless of the fact that it says exclusive of taxable fees and costs.
Right.
And yet, if you would have accepted this proposal for settlement,
Right.
you would have stood in front of the same judge and said, I want my taxable fees and costs in addition to the $15,000. Doesn't that create an inequitable goose versus gander sort of a situation here? You're
Why?
getting to look at this to exclude fees and costs if you want to accept it, but it includes fees and costs if you reject it. Where does that fall within the bounds of equity in reading both the
Well-
statute, the case law, and these proposals?
Because the trigger for fees and costs hadn't been accepted would have been based on the confession of judgment doctrine. So, the money paid after the lawsuit being filed, that would trigger entitlement to fees. So it's a separate analysis. It's a completely separate You know, and that's why I started with the fact that the procedural rule, you know, the only exception permitted other than the resolution of the entire claim is you can choose to resolve the attorney's fees or you can,
Okay,
It's not.
well, so would you concede to me that when you look at the White versus Steak and Ale case,
Uh-huh.
the whole case teeters on the fact that the court looks at this undefined term of what is net final judgment? What's the net judgment?
right?
You know, the court said that's undefined, and therefore we can't find that these prior cases were clearly erroneous, even though you've got two dissenters in the White versus Steak and Ale case that clearly say, look, if you look at the plain language of the statute, you know, final judgment means final judgment. It means the full judgment amount. It means pre-judgment interest, post-judgment interest, everything that's going to be in the judgment. Judgment equals judgment. And the only way that the Supreme Court, the majority, got to an interpretation that is what we're talking about today is because they looked at a term that was technically undefined and therefore ambiguous enough that they could tack into it this idea that we cut off judgment interest and we make this line in the sand that the legislature has not clearly made within the language of the statute. But the Supreme Court conceded that on both the majority and the dissent side.
In the statute you're referring to, 768.79.
Right. And
So
so my point is, counsel, if they could do that,
Mhm.
if they could say, you know, that there's this amorphous, ambiguous term in there that says prejudgment, you know, net final judgment does not include post-judgment interest, only includes prejudgment interest and costs up to the point of the proposal for settlement. Why couldn't we then take the next step and say, well, you know what? It's the same ambiguous term is there. The court didn't have these specific facts in front of them where they had a proposal for settlement that said exclusive of all taxable fees and costs. So why can't we just take the next step and say, well, hey, we've got this ambiguous term. Let's go ahead and shoehorn this in there as well. It's, you know, we're the 6th DCA. We're not bound by precedent. The Supreme Court isn't maybe clearly telling us one way or the other. Why couldn't we do that?
Because 627428 mandates that, and whether it's an actual final judgment or a compassionate judgment, it says that the fees and costs shall be included in the final judgment at subsection 3. So maybe this is a unique fact. This was a consumer protection statute that was in effect for over 100 years, but that's the distinction that I would argue. I mean, it's in the statute, it's plain, it should be in there that it shall.
And that, counsel, I know you're over your time, and that's entirely my fault. My colleagues are all looking at me. So
No, not at all. All right, thank you.
Thank you.
Forgot it was there. Please support. My name is Leila McDonald. I'm here on behalf of the appellee.
Yes, sir.
From what I heard, I believe that the court is trying to get to the bottom line of what a judgment obtained is. And by law, we know it's only the amount that can be done at the time of the service of a proposal for settlement. The jury came back with a $20,000 award to the appellant, and the court reduced.
counsel, since I was on fire with my questioning of the last attorney, I'm going to go ahead and jump right in and ask the question that I would like you to respond to, which is the same I'd asked your previous counsel that was up here.
Sure.
So the way I read White versus Steak and Ale, as I had just said, and I'll repeat it slightly, I think it all teeters on this whole idea that net judgment is not defined, and so therefore the court felt in the Supreme Court in the CCM case felt that they could look backward to White versus Steak and Ale and say, well, because we can't find that it's clearly erroneous because we have this ambiguous term in the statute, therefore we're going to uphold the White formula, which if we follow the White formula, I think you lose. But if we say, well, hey, if they found it ambiguous, and this is my question to you, why should we not say, well, just as the Supreme Court found that provision ambiguous and was not faced with the kind of facts we're looking at here, 6 DCA, let's go ahead and continue with this whole ambiguous line on this net judgment. and say that in a case where you've got a proposal for settlement that has the phrase exclusive of all taxable fees and costs, that net judgment now means exclusive of all taxable fees and costs. If you put that word in your proposal for settlement, that's how we're going to define it. Why should we or should we not do that here?
The proposal for settlement was very clear. It does not include attorney's fees, does not include taxable costs.
Doesn't that put you
15,000.
in White? And I'm sorry to interrupt this line, but my understanding of White, at least from the concurrence and the dissent in part by Justice Harding, was it was exclusive of costs. And you can quibble a lot with the reading that they gave it, but they did give it a reading. I don't know how we get around that reading in this case. So wasn't White exclusive of costs?
It was, Your Honor. In
Okay.
fact, Justice Harding said, quote, "In order to determine whether the term judgment obtained in section 768.79 includes costs, one must first determine whether the offer of judgment includes costs," and compares it apples to apples, not apples to oranges.
Right, but that's not the opinion of the court, and
That's just Judge Harding.
yeah. So how? In what world do you get around White?
Here we have an unambiguous proposal for settlement that excludes fees and costs for $15,000. After the reduction from the jury verdict, reducing it from $20,000 to $9,000, our proposal for settlement then kicks in because it was rejected.
That's not getting around. Well, getting around White would mean you somehow. Let me ask you this: do you concede that the pre-offer, that the SFR's pre-offer cost and fees exceed the threshold $11,250 amount? Meaning, if they were in fact included, then no fees for the carrier.
At the time that there was an evidentiary hearing, Your Honor, there was a plaintiff was seeking $23,145 in attorney's fees. At that point in time, there was no statutory basis or a contractual basis for attorney's fees.
It seems though
When it
that
was-
we don't even need to be talking about fees. I mean, I think my colleague's question is, if White applies, are they over the threshold based just on prejudgment interest and costs? You don't even get to fees. So you take the 9 and then you add the, I don't have the exact,
2,300 or so.
thank you.
And at that
Math
point-
never being a strong suit up here. That gets you over the threshold, does it not?
If the answer to your question, Your Honor, would be yes. It would. If the prejudgment interest were tacked on, then we would.
And the reason I ask, and because I did see that from the evidentiary hearing, but I'm not quite sure. There's no transcript from the evidentiary hearing, so I don't really know what everyone thought they were doing at the evidentiary hearing. And so I don't know if you would have been in a position to challenge that. And that's why I'm asking you now, are you challenging in any respect what was presented as and offered as the pre-offer attorney's fees and costs for the plaintiff?
Your Honor, that is beyond my knowledge.
Okay.
I was not trial counsel. I can only go based on the record that's being presented before this court.
Any reason to dispute the veracity of the supporting affidavits on those counts?
Only what the trial judge determined. And I just wasn't there. I'm so sorry.
That's okay.
But, as far as I understand from the record, the court entered its orders reducing it by $11,000 based on the Hurricane Irma deductible and other offsets that were by statute. So in my opinion, Your Honor, that the trial court did not err.
Let's say that White applies and that the trial court did err in that capacity, and that I can't get past the apples to apples, adopt the dissent as the majority argument. In that particular situation, is there any way that SFR could collect attorney's fees against the Department of Financial Services or FIGA?
The collectability is going to be a whole different animal, Your Honor. Even if this court were to reverse and remand to the trial court, at the end of the day, I'm not sure that the appellant could collect anything with FIGA.
Well, even collect. I mean, the statute, as I understand it, says that 627 does not apply to FICA with the limited exception.
Correct.
So it's not like, in your view, could there be a judgment against FICA? No. Okay.
No, Your Honor.
So what is your position? Because the brief didn't address the second position. Do you have a position on the second issue raised, meaning what we should do about the SFR's original fee request? Let's assuming White applies, the judgment in favor of the insurance company has to be reversed. What then, as it relates to the SFR's motion?
Your Honor, like I said, again, this proposal for settlement was exclusive of taxable costs.
Yeah, but we're past that.
Okay. I'm just making sure.
For this question,
For this particular question, Your Honor, if they were determined prevailing party for $20,000 after the offset of $11,000 to $9,000 on the judgment obtained, if the court were to tax on prejudgment interest at the moment that it was served, then if it goes over the threshold, then obviously we would not be, we couldn't really have a position on whether they were entitled or not. I don't know what the trial court, during the evidentiary hearing.
Do you think the trial court ruled at any point on their motion for fees?
Well, Your Honor, when I'm looking at the order on defendant's motion for judgment in accordance with a prior motion for directed verdict, and I'm looking at the order on defendant's amended motion for remitter, and I'm looking at what the court has done, the answer would be, as I agree with appellant counsel, implicitly denied. Sorry about being too long-winded on that.
No, that's fair.
To address the court, Your Honor, Smith, you had made a comment about the goose be gander. And I agree with you, Your Honor, on that. It shows an unfair balance and not inequity at all. And I agree with you.
I guess my struggle, if we were to go a route such as that, were we to take this ambiguous term and all of a sudden factor into it a new test and strategy coming out of the 6 DCA, does it really properly come out of the 6 DCA? Or is it the Florida Supreme Court that if they previously had looked at this ambiguous term, previously upheld the White formula, if they were to be presented with a situation like yours, which could have, frankly, some confusing, at the very least, results, as I tried to point out with my questions to counsel for SFR, where you're including taxable fees and costs if it's accepted, but then, excluding the taxable fees and costs if accepted, and saying you get it in addition to, and yet if it's rejected, then the trial court's expected to just look at the whole number altogether, included within the 15,000, which seems a little confusing, frankly. But is that something better set by the Florida Supreme Court and letting them make that sort of decision? And are we, as the DCA, should we be considered bound by the express language of the White versus Steak and Ale and the CCM cases? That's my struggle. I'll be frank with you.
Your Honors, I don't want you guys to get reversed from the Florida Supreme Court. That's a fair enough. I want this court to have all the facts and information that's necessary and to do what it needs to do to, uphold stare decisis, uphold the rule of law. This is an unusual case. I couldn't find anything on all fours.
Well, when was CCM decided? What year?
CCM was 2022.
So it's not eons ago, right?
That's true, but this case was actually, the final judgment was obtained in 2021.
So
So it postdates. with
You
the
know,
trial court.
the quotation from CCM is because this court's precedent is not clearly erroneous, which is when the Supreme Court is, the test that the Supreme Court is implemented to decide when it's going to recede from its prior opinions. We declined to recede from the White formula. Like, how are you not done? Like, I understand that you could make an argument theoretically that we were wrong in this particular case, which would be your right if you wanted to appeal it up and had the ability to do so. But how does White in combination with CCM not doom you on the first issue? You've already told Judge Netcher that both cases involved PFSs that were exclusive of fees and costs. I just don't understand your first argument.
Okay, thank you, Your Honor, for the opportunity to clarify. We're dealing with going back in time before that decision was rendered. So we're looking at the 2021 when that judgment was obtained. That's the year, that's the date. So the trial court wasn't aware of something that happens after the fact.
You still have White approximately 20 years.
That's
earlier.
true. White plays.
And you don't.
To
I
a certain
don't. I
extent.
haven't understood you to make, and you could be on some fairly solid ground in my for what it's worth from my perspective that White was wrong. Obviously, we can't do anything about that, but to the extent you wanted to preserve it, you could have made that clear, which I think might have been what Judge Traver was indicating. But you're not here seeking to preserve any issues for the Florida Supreme Court, correct?
I am bound to not make any disparaging comments about the judiciary. And the Florida Supreme Court is the Florida Supreme Court. If the court decides that it wants to recede from its decision in White, then it will, at one point or another.
But what I'm asking is, they're not going to do it unless somebody raises it, and you haven't raised that argument here. Obviously, appreciating that we couldn't do anything about it, but you haven't even made that. As I understand your position, it's this apples to apples thing, which I understand and completely from a fairness perspective, but it just seems that the ships might have sailed on that.
Again, we're looking at what the jury decided, what the trial court did pursuant to statute, which was proper. The fact that it's exclusive of attorney's fees and taxable costs is clear. If we go with White and its ambiguity argument, then I think that's where we have that disconnect. And I agree with the honors. I mean, if I had to preserve that on appeal, well, that should have been done at the lower tribunal. That's I can only go based on the record.
Anything else, counsel?
Thank you, Your Honors. May I be excused?
Yes. All right. Thank you both. We'll be in recess.